Hello and welcome to Rajya Sabha Television. You're watching The Big Picture with me, Frank Rausan Pereira. The government is finalizing new IT rules for social media companies that would mandate traceability of originator of information on such platforms and removal of malicious content within 24 hours of notice. Parliament was informed on Thursday. Now, the proposed new norms include deployment of technology-based automated tools or appropriate mechanisms for proactively identifying and removing or disabling public access to unlawful information or content. In December last year, the Information Technology Ministry had sought public feedback on amendments to IT rules for social media platforms and messaging apps in a bid to curb misuse of such platforms for spreading fake news. Messaging giant WhatsApp has in the past drawn flack from the government on the issue of message traceability. The government has been asking the Facebook-owned company to find ways to identify originators of rogue messages, but the US-based firm has resisted the demand, citing privacy concerns. On this edition of The Big Picture, we will analyze what changes need to be made in IT rules. Joining me on the program today are Jiten, Jain, online content analyst and, of course, cyber analyst as well. Karnika, Seth, advocate of the Supreme Court, and also with us is Prashant, Mali, cyber and privacy policy expert, and Munish Sharma, consultant, Institute for Defense Studies and Analysis. Thank you to all my guests for joining me on this edition of The Big Picture. All right, Jiten, Jain, let me begin the program with you. First, let's try and understand and analyze why is it important to identify or to understand where a particular message has originated from. Why is it important to track the origin?
So, there are two sides to it. One, if you try and track messages which are on the open platforms like social media platforms, be it Twitter or Facebook, it is much more easier to pin down an individual. They have some sort of tracks available, maybe the profile ID or the original profile where the profile was created. The problem, comes when you're trying to track a message which was originated on a P2P platform or a closed platform like WhatsApp or Telegram or any other instant messenger. Now here, particularly the popular tools like Telegram or WhatsApp, they say that they're deploying end-to-end encryption where they are not monitoring the content, they're not storing the content, and the content resides with the two individuals who are talking to each other. And whatever goes on between them, they cite that because it is end-to-end encrypted, they have no access or no way of figuring out that what is going on or where is the message originating and to how many people it is being forwarded. But I think that is a very flawed argument. Reason is that if you take particularly the example of WhatsApp, they cannot run away from the responsibility of from situations where a message needs to be tracked to ensure that there is no threat to public order or in the cases of national security. They say that because it is end-to-end encrypted, we cannot look at the content and tell you. But if you talk to several guys who've been dealing with this business, they all have a one common understanding that what minimum could be done was that especially photos or video, if you look at the total number of photos and videos which like people transfer or receive on WhatsApp, 98% of the content or 97% of the content roughly is a forwarded content. Only 2 to 3% is the newly originated content which somebody uploads for the first time on WhatsApp. That's are being like forwarded and recreated. Now in those 2 to 3% of content, especially where images and videos are involved, I think a content ID could be created. It may be a unique ID, it may be a hash value by using any salt, just an ID of the content.
But with the amount of content that is doing the rounds, so how many unique IDs we need to have?
Yeah, so that is not a problem because anyways you've got billions of users, you've got trillions of messages floating around, you very well know what to deliver where, you get blue ticks, double ticks when the message is delivered. You anyways are tracking the delivery of messages, the metadata of messages. So here we are giving a solution where we do not want to look at the actual content of messages, but only at the metadata, which would reflect the size and the origin IP of that particular video or image. Now, I'm not talking about text because that will be like trillions and trillions of messages, but photos and videos are, much more smaller in number. Now, majority of the riots which have taken place, majority of the public order situations which have come, they have happened because of some particular photo or video of some, hurting religious sentiments mostly. So, in those cases, suppose if you figure out a video, you could very well tell WhatsApp that this is the content ID of this particular video. Please tell us where was the origin user of this video and what was his IP address. I think that much WhatsApp could do. Now, WhatsApp also admits that the problem is that they are not citing as a technical problem, they are citing as a business problem. They don't say that end-to-end encryption cannot be broken. or it is sacrosanct. They said we will not do it because it will go against the very model of business, very fundamentals of business. It will go against our privacy policies. So it is not a technical problem. Basically, they are hesitating to comply from the rule of the land. Maybe they think that if they comply with one country, it will open a Pandora box to comply with many other jurisdictions. So here we are looking in an era where we have terrorist attacks, we have kidnappings, we have law and order situations. People are open. I mean, in Noida, I remember 60 lawmakers were threatened to pay ransom on bitcoins over WhatsApp sitting in Pakistan, and otherwise they were threatened that their personal videos will be shown to the public, and WhatsApp had no way to figure out that what was going on. So I think WhatsApp cannot shrink away from responsibility, especially in situations where people are dying.
Right.
So I think government has taken a very good view that we have to balance out. We don't want to look at the conversations, but we want to probably have access to good amount of metadata to track what is going on.
Okay, all right. Yes, Karnika, the floor is yours.
I agree with Jiten on this, that there is a particular possibility of getting the technical details even through WhatsApp. For example, if there's a digital signature, when you make a content and it is coming from a particular account, and in order to sign it, you have to apply the private key. There is a cryptography which is taking place. So encryption is like that. It is based on cryptography. And when you're creating the content and you're uploading it, there is a timeline. The first draft is something which is just the text or the photograph or the video, and then there comes the encryption layer, which is the second layer. So you can obviously make out from where it is being uploaded. So that's what I feel. And secondly, whether it is DNA photo hash mechanism, if they want to use DNA technology by Microsoft, that is also possible. You can check duplication of content for words of a particular hash value, pinpointing what he's trying to say is a content ID is actually hash value, and that is photo DNA technology. So I think this is the same thing we really mean, both of us, and that's how you can actually track messages and you can actually see the origination of a message. It's possible.
Okay,
yes.
It's possible. So it's not very difficult is what you're suggesting.
That's what I'm saying.
If there is a will, you can actually do it.
They're already deploying it.
There's a way.
They said in Supreme Court such a technology is not available, but I think they were exposed when a lawyer pointed out that if you go to YouTube today, if you upload a pirated video of any movie, it is struck down within like minutes. They very well can match the frames and content
ID. Even if you use a soundtrack on your own
so
content.
I'm sure you can use a similar technology for taking down child porn, you can do taking down terror content. I mean, if you get business, then you're using the technology.
Even from a legal standpoint, you have to give way to, protect national interest and integrity, sovereignty. Those are very grave reasons, on justifiable reasons, even as per our constitution, and calls for compliance. It's not something that you can choose to opt out of, but something which is very necessary, especially when national interest is involved.
Okay, all right. So, Munish, Sharma, let me bring you to the picture now. So, both the panelists before you have spoken about how there is the technology really to deal with this kind of a problem. Is the technology there? Secondly, is there a need to upgrade the technology as well?
Well, taking off from Jiten's point, I think it has never been a question of technology. Even if you look at the very origin of these debates over the last 2 years, the whole question is about privacy of the individual and whether these platforms are willing to comply with the law of the land. Like taking back from the cue from two key participants in this case, because I believe India is a very strong and very important market for WhatsApp by that sense. If you look at Russia and China, two other key markets which have in a way blocked, you can say, WhatsApp from operating on their territories. Probably I believe China was the first one in 2017 and Russia in 2018. Just because they don't comply with their local laws, this platform has been completely denied operating from these two countries. So in that sense, I think India becomes a very important player, because the decision which we take on WhatsApp or these platforms of providing a message traceability would be a kind of template for the whole world to look at. Because you have two extremes. On the one, you have the Western countries which are a way pushy towards privacy of the individual and those norms. On the other extreme, you have countries which are probably authoritarian in that sense of implementation of governance. So I think India's model is something which the whole world is looking at, and the way we will behave. I mean, the thing is, even if you look at the way we have, the government's argument has not been that you show us the content or you provide us the content. The whole idea is to figure out that where did it origin. And even if you look at the way traditionally how call records have been tracked, that's I think the nuts and bolts of surveillance, right? So a call detail record does not carry the content of a talk or the message which two people over SMS technology had exchanged. What a call detail, a CDR gives you is about which number has sent text to which number or called which number, for what duration, what was the jurisdiction, I mean which area it had called from. So all these details you can pick up and then you can connect the dots. So probably what government in this case is looking for is definitely not opening up the content what two individuals are sharing, but looking at how the message has moved. Like,
but that fear is always there.
Also, you see
Yeah.
the POC judgment, if you see the telephone interception case, very clearly says what are the parameters which need to be taken into account before you actually give out an order like this for interception for say, or it could be asking for some data from WhatsApp or other platforms. It has to be a justifiable cause. I agree that there has to be some sound basis and some evidence, not shouldn't be a fishing or a roving query. That's understood. But if there is some tangible basis, then yes, they need to cooperate. This is what I feel.
Okay, all right. Let me go across to Prashant Malina, who's been patiently listening to all the other speakers. Prashant, as far as companies or social media platforms like WhatsApp are concerned, they've been hiding behind this veil of privacy and haven't been divulging information. Are their arguments justified?
With no pre-existing law to privacy law in India, their well is only based on the right to privacy which Supreme Court has given us, and the laws existing in other countries what they're trying to lean behind. But primarily, it's completely their business decision, because revealing this identities also amounts to making money by their peers or some other companies and which they are directly indirectly associated to them. The most important point is, even if we bring this new intermediaries rules, which makes them compulsory to come out with metadata, we also need to make some changes with our existing laws for this metadata to be admissible as a direct evidence or evidence which is deducing something, because metadata per se would have lot of discrepancies. It will have a lot of arguments open in the court. Well, the defense will challenge every single deduction out of the metadata. And is the technology of this encryption decryption available across the world? Is WhatsApp done it before? It has done it before, so it is already existing. So there should be no discussion on this part at least. But bringing intermediaries this rules and making them compulsory, and after making them compulsory, when they do not follow what are the rules and what action government takes, is most interesting, because we have rules in place but we don't have what is the penalties in place and what is the deterrence in place, where when these foreign companies come in India, they just take us for granted. So once we have take some deterrence action, the first action taken by government of India would be most important to be seen in this parliament. So bringing laws and not implementing, the IT Act is there from 2001, and it's been so many years now, yet the implementation to its core remains a huge big issue, because the implementation mechanism and the implementation organizations, they are not geared up to take huge big decisions like this to ban organization completely. So it's the government's will and policy decisions which is very important in this aspect, and this is a very important thing government needs to decide on whether this data should be seen, data should be given to a law enforcement agency. Those are all the way it is seen that every evidence nowadays lies in this IMs, those instant messengers, whether it is WhatsApp or other messengers, what they're using. And they refuse to give it to law enforcement agencies, and because of this, there are many cases lying in different courts across the country which don't get decided, or which get decided in otherwise, in spite of having other kind of evidence.
Right.
So this rule should be vis-a-vis helping your law enforcement agencies. This should be actually enabling them to conduct a better investigation which leads to conviction, because India leads seriously in cybercrime related convictions, and conviction has to increase. Only this can't be a policy and business issues. Now the whole discussion, if you look at all the media around, is mostly on somebody is lobbying for it, somebody is against it. Nobody is clearly on what happens to our the criminal jurisprudence or the acquittals or convictions in our country because of lack of the data being given by this kind of companies. So that should be also a great focus. Instead of only business being the focus.
Okay, so the others also want to come in on the discussion. All right, Karnika, go ahead.
I just have 2 comments on that. One is when we talk about electronic evidence, our law has gone, grown many folds since what we knew earlier, and we have a clear section in even in the Evidence Act, and Section 65B is very, very clear on how to produce electronic evidence. Even if, for example, if I have a WhatsApp account and I have, chats on my WhatsApp, I can even produce that. And I can attach my certificate and say that, yes, this is authentic record from my device and it is not tampered, my phone is working properly. There are certain standard, things which you have to endorse and say that that is an affirmation, and put it on an affidavit and file the same along with the particular case that you're filing. So that's possible. Now, second comes the compliance. Compliance, cooperation from the WhatsApp or any other social media, they ought to comply, because there is, even today, IT Act says if they don't comply, there's almost a 3-year of penalty for that, imprisonment for that. So they have to comply, and that is the law of the land. There will be more changes now with the privacy law being strengthened, and certainly there will be more deterrent, provisions. But even as on date, they ought to comply. The point now is implementation, as Prashant is also mentioning. Implementation is definitely a challenge. Law is a paper tiger right now. We need to enforce the law. How we do it, what mechanisms we develop, and how we strengthen the same, the regime is the challenge today.
Okay, all right. Just taking that point forward.
You see,
Jiten, so implementation, how do we do that? Secondly, how do we ensure companies like WhatsApp and the others actually comply? Who's going to ensure that they are actually in compliance?
You see, we cannot, I agree with Karnika, we cannot have this thought that we do not have, enough teeth in the law to make sure this company, I think existing laws are also enough. What you need is the different interpretation of the law. Now, if you look at, I think it took us 8 years to send e-summons. It was Delhi High Court first which decided that you could send a summon on email, and if you get a read-write receipt, that means the summon has been opened and it will be treated as delivered.
Now we serve through WhatsApp also.
So we didn't have to change any law, but it was the evolving interpretation of the existing law. Similarly, there are many things which were not admitted earlier. Now, what I'm trying to say is that even the existing laws are capable enough to ensure that these companies comply. Now, for example, government under the IT Act has powers that law enforcement agencies can, intercept, snoop upon or modify any information originating, transmitted or created on any computing device. Now, many people during this entire NSO debate were saying that, where it is written that government is going to plant a malware on the phone. You see, then there are varying interpretation of what is a computing device. Even mobile is a computing device. What is the information? If malware is, maybe there is nothing called a malware, it is only a way to access information. So what I'm trying to say is that, these companies, we should not wait for the laws to be, changed or modified. Even under the existing laws, if these companies do not provide and do not, cooperate with the law enforcement agencies, they can still be, sued for criminal connivance. So, I mean, if for all the cases, so if law has to be modified, I agree with Prashant, but we should not wait for the new laws to come in. We should use existing laws very forcefully and set examples.
Okay.
If a court orders, they don't obey, there will be a contempt of court immediately, and that needs to be looked at very seriously.
But these companies at the end of the day, like we've been discussing, don't seem to be concerned or don't seem to be too worried about the existing laws.
I'll give you an example. The admissibility of evidence, what Prashant is talking about, the metadata, there will be so many questions, interpretations. You see, earlier, if IT Act says that if you seize any electronic device, it has to be seized first. And the Panchnama has to be created and then it has to be sent to a forensic lab. Then people realized there was a problem with the email. You can't seize an email, right? And if you leave it open, the person will go out, he'll tell a relative his password, they'll format everything. So in last 2 years, law enforcement agencies, when we had several conferences, we figured out a new way that let us access his email in the front of 2 witnesses or maybe in the front of magistrate, change his password and bring it on record that we accessed his email in front of him by obtaining his password. We have changed the password and there are 2 evidences. So that is a new way of sort of having digital confiscation of evidence. Now it is admitted. So tomorrow, this metadata also, initially there will be teething problems by the interpretation and admissibility of metadata. But over a period of time, our courts, our judges are capable enough to interpret it in a way that it serves both the purposes.
Okay, all right, Munish. Is there taking the discussion forward now, is there a fine line between privacy concerns and fundamental rights and, the state's interest?
I have always found it to be a zero-sum game. So what eventually happens is that once security requirements, they take the front seat, then obviously privacy has to go to the back seat. And we have seen this happening all across the globe, especially in the aftermath of terror strikes, where WhatsApp was found to be one of the mediums for person-to-person communication, and especially when it's end-to-end encrypted. And when law enforcement agencies don't have access to the content, or probably some arguments came after London attacks, 2015, 2017, I think, Paris, if you put together, that these things could have been averted had the law enforcement had any visibility on the content which was traveling or which was being exchanged between these groups.
But how much of visibility is good or bad?
That's the whole question, because it's too difficult to maintain a very thin line. You never know when do you breach into individuals' privacy in the name of or in the, at the behest of national security.
Because the same state is then going to be accused of snooping.
Exactly, and that's why I think the debate right now is on all across the globe, and nobody has as of been able to find a credible solution except banning these applications outright. So probably if we take a very practical and a workable approach, I believe banning them outright would not be the safest option for us. But how do we work out a model? How do we make sure, as the other panelists were saying, that how do we either kind of fine-tune our existing framework, the legal framework, or how do we strengthen the existing legal framework to make sure that implementation is to an extent quite strong in that.
Okay, let me go across to Prashant and see if he has a way out or a way forward as far as this issue is concerned. What is the best approach? What is a practical approach going forward, Prashant?
See, now there are two aspects to this. One is the privacy. And when it comes to privacy, encryption definitely helps. Like it is proved across the world, encryption actually goes ahead, and there are activists around, having this encryption policy in place to protect your privacy. But then the other question is about law enforcement and the sovereign control of the state over all this communication happening, because it is affecting lives of people. And second point is now it can has power to change governments also. So because it is impounding on legs of government, the question of sovereignty arises, and everybody wants to jump into this. And in India, because all-time awareness or the activism about encryption technology is not that much, or the activism is not that much, they are taking this great advantage of bringing in national security and our laws are tuned such that once there is a proviso of national security, everything is it's taken care of. So this point on they are fighting. So as of date, if you see, if privacy versus law enforcement issues, if we are looking at, then we are going to sacrifice privacy over this law enforcement issues, and this is already happening. So everybody knows on our panel also, when it comes to national security or law enforcement, they don't follow all the rules by the book. There's already breach of privacy. In India specifically, privacy is already a myth, and as it's only been granted by Honorable Supreme Court, but yet to being framed as a law. Once the law gets framed, the Data Privacy Act, the Personal Data Protection Act, which is impending, possibly happens since this winter session. If that happens, then the scenario would completely change, and we can come on the panel and discuss this completely differently, because then we'll have a law of the land, and then it will have definite penalties, that will have definite things, and then WhatsApp-like companies also will become more serious towards it, because there is a legal risk to it and there is money involved in it.
Okay, all right.
There is a business. So there is an image risk and a business risk.
Okay, all right. Time now to get closing comments from all the guests. Starting with you first, Karnika, Seth, with the best way forward. What's the best way forward?
Well, I think this law needs to evolve. We need to find technical solutions, the legal solutions, and it's not something only privacy and law enforcement is the issue. There are other issues. It overlaps with defamation law. It overlaps with personal information. It overlaps also with other, key issues. It could be anything to do with trade secrets. It could be anything. Fake news, for instance. Fake news. When you talk about fake news, that has a different treatment altogether. altogether. If somebody sharing private information is a different law altogether, and they all need to evolve together. It's ultimately one medium, social media, and it runs all across different kinds of information. So they cannot be one single treatment for every kind of information.
Okay, all right.
I think what we lack is a very informed debate in society. We are having passionate debates instead of patient arguments. You see, the moment government says that we want to monitor social media to prevent fake news and this plant of instigating rumors and stuff, people start shouting that no, look, government is going to snoop on our conversations. How dare government snoop on our social media conversations? You see, when government talks about social media monitoring, they're not talking about your personal chats. They're talking about monitoring the open content, like monitoring traffic on streets. At the same time, the moment you ask this instant messenger companies to provide some access to the content, they are like, this does not happen in our country, this is against privacy, this is not the way the law works, your government is different from our governments. But they also have to understand this demand of access to this content is not only coming from India, it is coming from the top, one of the most celebrated democracies across the world, France, Germany, United Kingdom, America, they are all celebrated liberal democracies. Even their prime ministers, head of states have been continuously asking WhatsApp to provide access to the conversations and content under certain circumstances. So this is where we have to understand, and we as a society, we have to understand that, even if we leave national security apart, the privacy of a state, privacy of a nation, privacy of a society is a superior right than the privacy of an individual. Sometimes to protect the privacy of state, you may have to temporarily suspend the privacy of an individual.
Right.
And this so-called right to privacy judgments which have been come from, from different courts, Supreme Court and couple of high courts. See, these rights are not absolute. Even right to life is not absolute. It cannot be suspended under emergency, but even during normal circumstances, courts take away life by giving capital punishments.
Sure.
So certain time law enforcement agencies have right to temporarily suspend your fundamental right of privacy under certain situations to ensure that the larger public order and the public safety is maintained.
So all cannot be put in a straight jacket. It's not one formula which fits all kinds of information.
Sure. All right, Munish.
Well, I look at it as a three-dimensional problem, and the solution itself is three-dimensional. And first and foremost is the law, because law provides you the basic understanding of how things are, and if somebody breaches the line, then how he should be prosecuted. And having said that, it also means that if you have to make sure that law is not abused. These kind of arrangements, they are not abused, even if we go ahead with something called as backward traceability or in that sense. But second key dimension here would be technology, which has always been there, and I believe that if the need comes, then it should not take long for any of these platforms to bring that into the fold. And third important dimension, according to me, is the human dimension, in which you make people aware that how you should refrain from forwarding or identifying fake messages or fake news, and how they should refrain from instigating probably messages or instigating violence, which could be detrimental for our society.
Okay, all right. And Prashant, close the show for us with your concluding remarks.
So to conclude, everybody on the panel as of right now say this, that should be the solution. Privacy cannot be an absolute right. And when the law enforcement agencies or the country needs your privacy to be compromised for the sake of national security, it can be done, it should be done even as what the law suggests. And the solution lies, since the problem lies in the technology, solution also lies in the technology and with the people, because people are its users. So, and solution will come as the time progresses. We can debate on it all the time, but the time is the best, decision maker, which will make it, because the technology will also evolve. So many things will get added to the existing app which we are using. AI will get added, ML will get added, and things will evolve all the time. So this intermediary rules which is impending right now has to also evolve, and this should be at least a bi-yearly process. It can't be 2011 and 2019.
Right.
So this gap has to be gone. I keep saying all the time that this IT Act should have the last section which should actually define what is the next amendment date for the IT Act itself.
Okay.
Because you can't have an IT Act sitting, the amendment dates can be 10 years of it.
Okay, all right. On that note, then we'll call it a wrap on this edition of The Big Picture. Thank you to all my guests for joining me on the program and putting things into perspective for us. What's coming out of this discussion is that national security trumps your right to your fundamental right to privacy, and also there is the technology that is in place to ensure that the origin of the content can be traced, but it is the will that is lacking as far as the social media platforms are concerned. There is a need to amend the laws, but even with the existing laws, they have enough teeth really to go after some of these social media platforms, is what the panelists are suggesting. With that, it's a wrap. See you again next time.